Okay, so we've discussed your children, we've discussed your will, we've talked about in prior videos about your power of attorney, your healthcare documents, and let's talk about trust planning, because the reality is if you want to stay out of court, both guardianship court and probate court, you're going to need to work with trusts. That is the reality of it. That's how it works here in Florida. There is no administration without probate. That doesn't exist here. It's only available in a few states and not in Florida. Okay, so trusts, it's a long thing. It's a big checklist. So I'm breaking it down into parts. So we're going to cover 10 points first about trust today. Okay, let's talk about it. First of all, trusts. Is your trust well identified, properly identified, meaning the full formal name of the trust? Is it in there in the beginning of your document, right? To avoid confusion. Why? Because if you say the Smith Family Trust, guess what? There's a lot of Smith families, right? So this isn't sufficient to identify your trust vehicle, right? It's got to be properly identified. Trust certificate. Is there a trust certificate for financial institutions? Why? Because you don't necessarily want to give all your private things and information about how you want things distributed and all that to financial institutions. So do you have a trust certificate that lets financial institution know just the essentials about your trust? And that certificate of trust needs to be valid and up to date. So, number 3, do you have funding provisions? Okay. Does the trust state that it is instantly funded upon creation? Why? Because the reality is that a trust that is not funded is not a trust. For legal requirements, for a trust to exist, there has to be a trustee, a beneficiary, and assets. If you don't have that third leg, you don't have a trust. So, does it include provisions that essentially create and meet all 3 requirements? Okay, asset ownership characterizations, right? Does the trust really clearly state what is joint property, what is separate property, what is community property if you're in a community property state, right? These provisions are necessary because if you're married, guess what? Not everything that you have is going to be jointly marital, right? You're going to have separate assets, but if your trust doesn't identify these things separately, it's all going to get treated the same, which is going to be really upsetting if you have divorce filings. Then it can be used as proof that both parties considered everything to be marital. And so make sure you're really careful about this. Okay. Powers to act alone. Does your trust include provisions that say that people can act alone without having to have their spouse also sign along with everything? These are things to discuss with your estate planning attorney as to the reasons why you might want provisions like this, but does it talk about these provisions? Revocation provisions. Does it say how you get to revoke the trust? Really important. Names of family members. Does it specifically identify who your family members are, right? Maybe their dates of birth if they're minors, their relationship to you. All of these things are essential and important, especially in the event a conflict arises. The more ambiguous you are in your trust, the more likely it's going to result in really expensive litigation. Incapacitation. Is there a clause that says, here's how we determine if a trustee is incapacitated, right? How? Who gets to determine if they're incapacitated? Those things need to be included in your trust. 9, ability to remove the trustee. Does your trust agreement include those provisions that say, okay, here's how we're going to remove a trustee, and here's what we considered irresponsible behavior of a trustee or a no unacceptable behavior on the part of a trustee? Does it include those provisions, right? And then finally, out of this part that we're covering today, right, is there the ability to appoint a trustee, a new trustee in the trust, and how is that determined? Where do these new trustees come from? What kind of a pool of people are acceptable successor trustees, right? Because you never want there to be a vacancy in the trustee, because remember those 3 legs I said, right? You've got to have assets, you've got to have a beneficiary, and you've got to have a trustee, because if you don't have a trustee, you don't have a trust. All right, so that's the first part. Remember, if these things are not in your plan, you do not have a proper estate plan in place.